Good morning. I'm Ken Bamberger. I teach here at the law school, and I'm a faculty director of the Diller Institute for Jewish Law and Israel Studies. And I'm so happy to welcome you to this event celebrating the Institute's 10th anniversary on the Berkeley campus, and of course, our new name. Shortly, I'll turn things over to UC Berkeley Chancellor Carol Christ, for whose bold and caring and forward-thinking leadership during challenging times has brought our campus to new heights, and whose support for growing Jewish and Israel studies at Berkeley has been nothing short of extraordinary. But first, I invite you to view a short slideshow celebrating the Institute's 10 years of accomplishment.
Welcome to the Helen Diller Institute for Jewish Law and Israel Studies. Created in 2011, the Institute has changed the face of the Berkeley campus in regards to Israel studies and Jewish law, thought, and identity. In just 10 years, we have enriched the campus with over 100 courses, attracting a Berkeley faculty cohort of 22 and over 40 visiting Israeli faculty. The Institute has created a global community that engages students, faculty, and the general public through seminars, symposia, performances, and conferences, drawing on scholars and collaborations from around the U.S. and Israel. Our virtual programming has expanded the reach of our landmark public programs beyond the Berkeley area. We continue to innovate our student experiences with cross-cultural exchanges and experiential learning programs in Israel, providing opportunities for undergraduate support and mentoring, and offer a robust undergraduate fellowship program. We have brought a premier group of speakers to campus, featuring prominent journalists, academics, legal scholars, justices, writers, and artists. A major endowment from the Helen Diller Foundation builds on other generous gifts to secure our future as we look beyond 10 years, to build an Israel Studies minor, augment experiential learning in Israel, and grow our reach. Join us for the journey.
Welcome to the 10th anniversary naming celebration of the Helen Diller Institute for Jewish Law and Israel Studies. I'm Chancellor Carol Christ. It's wonderful to be with you today. More than 300 people registered to join us for this exciting program. In its first 10 years, the Institute has already left an important imprint on the campus landscape, transforming the curriculum in Israel studies and augmenting Jewish studies with more than 100 courses to date, enriching the faculty and student community culturally and intellectually with more than 40 visiting Israeli faculty in a dozen different departments, from anthropology and geography to history, law, and political science. Bringing prominent scholars, writers, and intellectuals, Michael Walzer, Susanna Herschel, Edgar Keret, Syed Kashua, Dennis Ross, and planning thought-provoking programs, conferences, and symposia to campus on the legacy of the Nuremberg trials, Israeli arts and society, defining and combating anti-Semitism and hate online, and much more. At the core of the Institute is its focus on engaging and empowering students in the classroom, in student-centered programs and student-taught courses, or decals, in its undergraduate fellows program, and in innovative experiential learning programs such as the Global Internship Program in Israel. Over these past 10 years, the Institute has grown and flourished in the supportive environment of Berkeley Law. It marked its beginnings with the crucial support of Dean Chris Edley, and it currently thrives under the engaged leadership of Dean Erwin Chemerinsky. I want to thank and acknowledge all of the generous funders who have supported the Institute since its inception. The Institute is here today because of their initial belief and investment in the institution's mission. The Koret Foundation, the Rosalind and Arthur Gilbert Foundation, the Jim Joseph Foundation, the Lisa and Douglas Goldman Foundation, the Israel Institute. Today, we celebrate an important endowment from the Helen Diller Foundation. This remarkable gift ensures that the Institute can continue to contribute richly to the academic and intellectual life on the Berkeley campus, and to the diverse cultures and communities with which it engages. Their generous investment and the naming of the Helen Diller Institute for Jewish Law and Israel Studies gives the Institute a strong foundation on which to plan for its future and to envision bold initiatives. I'm now going to introduce our speakers. Please join me for an intimate conversation about compelling issues in Israeli and comparative constitutional law between Berkeley Law Dean Erwin Chemerinsky and former Israeli Chief Justice Dorit Beinisch. From 2006 to 2012, Dorit Beinisch served as the 9th president of the Supreme Court of Israel, the first woman in Israel to hold that position. Justice Beinisch was appointed to the Supreme Court in 1995. Prior to her elevation to the court, Justice Beinisch served as Israel's state attorney, the first woman in Israel to hold that position. In that role, she directed all government litigation at all judicial levels. Erwin Chemerinsky is the Dean of the University of California, Berkeley School of Law and the Jesse H. Chopra Distinguished Professor of Law. Before coming to Berkeley, he served as founding dean and distinguished professor of law and Raymond Pike Professor of First Amendment Law at the University of California, Irvine School of Law with a joint appointment in political science. Dean Chemerinsky frequently argues at appellate cases, including in the United States Supreme Court. In 2016, he was named a fellow of the American Academy of Arts and Sciences. I turn to Dean Chemerinsky to begin the conversation.
Thank you, Chancellor Christ, so much for that wonderful introduction. It is a great occasion to celebrate the 10th birthday of the Helen Diller Institute for Israel Law and Jewish Studies, and to also celebrate this wonderful naming gift. I would be remiss if I didn't take a moment and express huge thanks to the two people who have played such an instrumental role in getting this off the ground and having it thrive. And that's my colleague, Ken Bamberger, and it's also Ron Hassner. The two of them as the co-directors are really responsible for making this the leading institute on Israel law and Jewish studies in the United States. And I cannot think of a better way of celebrating this birthday than by having this conversation with the former Chief Justice of the Israeli Supreme Court, Dorit Beinisch. And I have a lot of questions that I want to ask you, Justice Beinisch. So let me start by asking you, why did you choose law as a field?
Just a minute. First of all, I want to thank Chancellor Chris and to thank you for the introduction and tell you how I'm excited to be with you on this celebration, because really, I think this is such an important institute, and congratulations for the naming of the Helen Diller Institute. I must say that I cherish very, very good memories from visiting this institute. I think it was 2013. And you've done since then so many achievements you have, and I'm glad to be with you on this celebration. Now, I must say, it's not easy for me to answer your question. It wasn't that since I was a child, I thought about learning law, not at all. I don't know, it was a decision that I took on the spur of the moment after I first thought that I'll be in humanities and not in law. But when I understood the last minute, when I just went to the university, to the law school, that law has such an important role in society, that law has a role that should be good for our society. And I thought we can contribute through law. And this was just how I came, almost by chance. Instead of literature and humanities, I went to law school. And the rest, you know already. This is how it went.
After law school, you made the choice to go into government service. You
Yes.
spent your career before going on the bench in the state attorney's office. As
Yes.
Chancellor Christ pointed out, you served in that office from 1967 to 1995, serving as the state attorney from 1989 to 1995, the first woman to hold the position. Why did you choose that field? Why going into the government for service?
Well, this you can see, this is what I said before. I think that the most important contribution that we can, as law people, give to society is in public service. And I always thought about this field of public service and everything that could be important for society. I never thought about a private career. So never, I don't know, even when I had opportunities. I loved my work and it was interesting. And I think those years that I served in the Ministry of Justice, it was 28 years. It's a lot. But, you know, every day was a new day, a new case, another thing. And I loved to argue cases in the Supreme Court and other courts, but especially in the Supreme Court, and to solve problems that we had in our service. I have really, it wasn't easy, but it was important for me and a great time.
In what ways is the state attorney similar to our Department of Justice? And are there ways that it's different than our Department of Justice?
Yes. It was very different. It is still different. The head of the hierarchy in Israel, like in the United States, is the Attorney General. The state attorney in the office is actually formally number 2 of the office, but the head of the prosecution and the litigation. And it's very different. I mean, it's not the Solicitor General like in your system. It's more similar to Attorney General. And we have what was very important during the years, and I hope it will remain like that. We are never showing our political crisis that we have, that the Attorney General and the State Attorney were very independent figures in the field, professional, and although they belong to the administration, it's not a political nomination, and it's really what is so important in my view is the independence of law enforcement, the same as the independence of courts, of course. So this is what I like so much. It's not really, it is similar in certain ways, but the Department of Justice is different. And of course, as I said, the figures that take those roles are very independent, professional. And now it's part of the criticism of politicians because sometimes we have to do the work not as they like and not so popular. This was part of my life too.
I'm interested in following up on the independence. We certainly had a great deal of criticism of the Justice Department in the last 4 years in the United States of there being too politically motivated and too much influence on the president. What created the independence for the state attorney's office in Israel? Is it structural in terms of who appoints and removes? Or is it just about the norms of the office, or both?
Both. And this was if I can say, not a constitutional tradition and accepted, because the Attorney General and the State Attorney are appointed by the government. So it's a difficult position from that point of view. But until now, our system of civil service was a professional civil service, not political. We are not changing when the government changed. And I had the opportunity to serve governments, you can call them right and left, since it was Rabin, it was Shamir, it was all the prime ministers during the years. They did not interfere to change the people who function. So now independent is maybe, when I'm talking about independence, it looks too great. I mean, of course, we represent the policy of the government. We are not policy makers, we are professionals. And as long as we can do that, we represent in courts and in our policy, the policy of the government. But sometimes we are the limits of the law put on the government. And I must say that now we are in a very critical point in our political life because they don't like it so much. And then they try to say, well, who are you? Why are you independent? I never heard it. I heard a lot of criticism when I was in office. And sometimes they would have been very happy that I would not be there, but they couldn't do anything about it. That's the way it works practically.
28 years is obviously a long time. Are there particular cases that stand out to you as you look back on that? Are there particular things that you handled in the state attorney's office that you're most proud of?
I think we did a lot of important work. I mean, the office, which has branches all over the country. We have 8 offices in North, in the South, but all is concentrated, of course, in the Ministry of Justice by the State Attorney and the Attorney General. You know, we had in different times special missions, if I may say so. So my cases were sometimes even not easy, facing government demands in trying to keep security issues, keeping that the security people will keep the law. We had a very big crisis as to Prime Minister trying to protect security service when they were not acting as we thought according to the law, and this was a crisis. I was the prosecutor of the Jewish underground that we had, and the Kahana people, which was all the extreme racists that we thought shouldn't be there. We even declared them out of law. Now some of them are in our Knesset, but this is how it was. And of course, corruption in government, corruption in departments of government, and especially in our very special situation, having terror in Israel, having terrorists, yet keeping the rule of law, and the military respecting law in spite of the fact that they have to fight terror. All these things where we were occupied with when I was a state attorney, a lot of those problems. And we had it in the court too, of course, because this is part of our reality.
Let me follow up on a couple of things you said. I think the first time I heard of you was when you were the state attorney and there was the action to ban the Kahani party from participating in elections.
Yes.
And you alluded to that. I'd be really interested in your perspective about banning a particular political party because of its extremist views, as opposed to allowing it to exist and having the voters make the choice.
Well, this is a very complicated issue. I try to tell it briefly. It's not because of their extreme ideas. It's more than that. I thought that, and it's your field, I think, freedom of speech, freedom of expression doesn't really protect racism. This was my view also when I was in court. Not everybody agreed. So one thing was the racism, and the problem was before the court approved Kahana coming to the Knesset when he was elected, because there was no special paragraph in the law that banned a party, a political party. But then the law was amended, and we can ban a political party if it's for the purposes, the aims, the idea of the party is against, of course, the existence of the state of Israel and for terror and racism, which may endanger democracy. And the problem of banning Kahana was because we thought that what he did and said and incited is really endangering our democracy. And we have a fragile democracy. We didn't speak yet about, of course, the constitutional situation. And this is one reason. The other thing, our political structure is, in my view, not everyone agrees. Every member of the Knesset can be a deciding voice when you need only his voice to come and join the government. So when you have a terrorist, someone who incites for terror, or someone who is racist, obviously, not that he doesn't like these people or the other, this endangers democracy. And I thought this was one of the things. So first we argued it in court and we lost it because there was no special law against it. Then there was legislation, and I came to the court to argue the case against Kahana, citing what he said and what he strived to achieve, and he was banned according to the law. I think it's very strange for Americans, but if you think the experience, the historical experience, so Germany has a law like that, and I mean only the real extreme danger would be a justification to ban a political party, of course. It's very delicate, and I understand it.
Thank you. That's a wonderful answer. Thank you. I wanted to touch on something else, and this can also be part of the transition from talking about you moving from the state attorney's office to the Supreme Court. And you alluded to the tension between civil liberties and security, especially with regard to terror. Since Israel began as a nation in 1948, it's had to deal with existential threats in terms of terrorism. When the United States began dealing with that after 9/11, we looked very much to how Israel had struck the balance. And I know that a number of the opinions of yours that I read involved this kind of issue. When you were the state attorney, did you have a different perspective with regard to this than once you went on to the Supreme Court, because your role was different?
It wasn't different. One of the important things in my view, when you know that you will have to represent the case in court later, you represent the court's view to the administration. I mean, and this was at the time of Prime Minister Begin, his instructions, that the military could come to us for an advice. If something is proportionate, if the means that they are taking are not exaggerate. We were involved not in deciding, of course, what they should do. This is not our profession, but the limits of the law. And I think the idea that people in a very strange situation, which is very Israeli, on the one hand, you have really the fight against terror. Your 9/11 was our life. In 2000, we had many 9/11s, if you can say, when buses exploded and restaurants exploded, and the situation was terrible. But you have to remember that the power that we have, especially in keeping the territories, is so strong that the only restraint when they deal with civil population in the territories that Israel keeps, if you don't put the real balance, to strike the balance between the real security needs that we do have and as much as we can implement the rights, human rights, this is our role. And I think what made it easy, the transition from the state attorney's office to the Supreme Court, is I didn't change my views, not being there and not when I went to the court. This is the legitimate balance that we have to put carefully. Not easy, not popular. Sometimes you take decisions, it's really not popular. And sometimes you have to confront the military people, prime minister, telling him this is impossible, we are not allowed to do that. Usually they don't like very much our opinions, but they knew that they have. And I think this was one of the important roles of the court. We cannot change, there is criticism here, we cannot change government policy. Not the court will decide if we have settlements or we don't have settlements. This is not for the court. But how do we protect our people and the settlements and the territories and the people there, keeping the rights as much as possible, even in times of danger? This is part of the legal profession.
You go on to the court in 1995. You become the president of the court in 2006. Was it a hard transition from being advocate to being justice?
Not really. That's what I tried to explain. I didn't change my views. I mean, even it's of course different. It's a different case. You are not taking a side. You have to be objective. But I also believe that the people in service of government should also be not objective, of course. As I said, we represent our government, but keep the rules very strictly. I didn't feel that this is a real problem. You always, even if you represent the government, this is the difference between private career and public service. You have to see the other side too, the rights of the defendant too, and this is part of your work. Of course, the weight is different in your decisions, but I believe that it wasn't such a big contrast.
In Israel, there's not a formal constitution, but you have the basic law. One of the things that happened in your time on the court was creating the ability to review legislation. Could you try a little bit about how the Israeli Supreme Court created this, found this authority, and how different it is from the United States, where we do have a written constitution?
Yes, it's very different, and it's you see, the Constitution, I don't have to explain to this forum, the Constitution reflects the norms of the people of the state, the norms and the structure, and the rights. And this reflects the history and the education and the culture of the nation. When the state was established, this was actually in the foundation of the state, this was the right time to have a written constitution. But our history was like that, they didn't come to an agreement for very important issues. And until today, it's not completely finished. And this is religion and state, security matters. And I think when the state was founded, Ben-Gurion, our founding father, followed the British. This was the model. And a parliamentary system, and we don't need a constitution, a written constitution. But there was an obligation, a commitment in the declaration of the state to have a constitution, because this was when the United Nations decided on the partition of this country and the state. So they decided to have chapters. Chapters will be covering different issues of constitution. So the structure of the state, the parliament, the government, the judiciary, they are all in basic laws. Those are our constitutional laws. The problem was with the human rights. Until 1992, it was the court that had a very important role in establishing human rights as norms that are binding, especially political rights. They were all put by the court. The court since 1948 until 1992, it was only common law that was binding in the state for human rights and guaranteed the freedom of speech, all by judgments of the court. Now, how do we take the power, the authority to review legislation? This is because in the law of human rights, the basic law of human dignity and liberty, there is a limitation on legislation. It is and I'll tell you. And actually what the court did is something, we took the Marbury versus Madison case. And this was the guideline exactly. And because the basic law shall not, part of it is that it should be for a purpose, for the purpose. And I am just trying to find out what is written exactly in English. There shall be no violation of rights under this basic law except by a law befitting the values of the state of Israel enacted for a proper purpose and to an extent not greater than is required. This is our proportionality rule. And this is where we took the power. I mean, it's President Barak who was the Chief Justice that decided to do that, and the court accepted. And our parliament, our Knesset, wasn't very happy for this interpretation, and still we hear about it more than once. And this is one of the political issues here. And yet, this is how we do. If because of this, this section 8 of our, that I just cited, the court has the power and accept it. The issue now pending in court is, does the court have the authority to review a basic law? Not derives from the basic law, but the basic law itself. And that's the situation now. It is pending about the basic law of national, I don't know, anyway, this is what,
Thank you.
where we think, or some think, that the Jewish values were put above democracy values. So this is now the issue.
I want to ask you about some of the specific matters that you dealt with while a justice on the court, but I also want to back up. You were the first woman to be the state attorney. You're the first woman to be the president of the Israeli Supreme Court. What's your perspective on having been the first woman in those roles? Do you feel you had to overcome particular obstacles on account of your sex?
There are obstacles, of course, not, this is a problem of equality. From the legal point of view, we have equality for opportunities, not everywhere. In the legal field, more is the situation is much better, much better. I think, and when I was the first woman, I must say, until I heard the reaction of women, I didn't realize that it means so much to people or to women. I thought it's natural, but it wasn't so much like that. And this is part of it. There are fields that we have a lot to do to promote the equality of women. There are certain fields. From the legal point of view, we were more advanced when the state was founded, I may say, more advanced than the American society. If you read the cases of late Bader Ginsburg, and you see the achievements were slower. We had it already, but still, this is an unfinished, unaccomplished mission to have a real equality, not only in law, but in life and in all the positions that women have.
Thank you. You served on the Israeli Supreme Court for 17 years, which is also a very long time. Are there particular decisions that you wrote that most stand out to you, that you're most proud of?
Well, it's not for me to say, actually. I thought one of the most important things was that the judgment that banned or prohibited corporal punishment of parents to children, which is not natural until today, and not only here, but this is a case, an Israeli case. So this was, in my view, very important. I'm glad we made it not to open private prisons in Israel. This is also was one of my, I thought it's very important. And then it's a daily work. Every case is important. In every case, you have to invest a lot of time, a lot of thought. And I think we did the work.
My editorial comment is, I wish our Supreme Court would outlaw private prisons and outlaw corporal punishment too. They should copy your court in those regards. What about, to go back to the balance between civil liberties and national security? Many of those cases came before you as a justice. Do you have thoughts about how you as a court struck that balance?
How do we strike the balance
Right,
between?
when you were justice on the court and some of the matters that came before you that involved the Palestinian territories, the fence that was being built, which of course
Yes.
resonates with the wall that our prior president wanted,
Yes.
or particular army practices.
Those cases were very difficult, very, because as I said before, we are not deciding what are the security needs and is it needed or not. We have to accept if the military expert decided, let's say that we need the fence, the security fence, the wall, it should be taken to build it. And this was again in the time when we had suicide bombers. And it was a real danger, the cars coming in from the territories and bomb inside the civil population, very difficult. Yet we took the measures according to our basic law, to keep proportionality, not to take more land than needed for defense, not to put it in a place where it hurts more people. We had more than 100 cases like that as to defense. All of them, the court went into details. We are first and last instance. So we had to go, we had with aerial photos and we saw exactly where it is and is it really needed. We never challenged the need to, we accepted that the generals, the military said that we need this fence for security, but where to put it, how much land to take, how much it infringes upon the rights of the population, this is what the court reviewed. So.
One of the things you mentioned at the beginning, time as state attorney and on the court, was the focus on corruption. And I know that one of the things that you're most known for is your anti-corruption efforts. What are some of the things that stand out for you that you were able to accomplish in that regard?
What did we accomplish?
Or what would you look back on?
This is now one of the most important issues in the country, so I cannot say too much about it. The thing is that you don't accept the idea that the law is equal and you have to enforce the law on everybody, and power corrupts and you have to be careful, especially at the beginning it was problems of police people, which you know so well in the United States, police. The problem comes when you have to deal with politicians and this is so sensitive and you have to be so careful. But institutional corruption, as I said, especially police or other departments, that you have to see that they will have overview and they will have supervision and to build the institution that will see to it that you can fight corruption. Sometimes it's frustrating. It is a unfinished work always. When you think you achieved something, you don't know what will be the next step. Yet, I believe that as long as the prosecutors, the people who are responsible for law enforcement, think and accept that everyone should have take the results, the burden, if and equally be dealt with, no matter how important this person is or what is the figure, and the institution, the army, the police, if they have all the institutions to keep it, this was our role to see that things will be taken care of and of course, to deal with it. You never, then it's not a corrupted country, God forbid. It's not. It's sometimes corrupted people, and with this you can deal, and you have to.
In hindsight, are there choices you made as state attorney or as a justice that you regret that you would do differently in hindsight?
You mean if I would have seen it differently?
Right.
Today?
As you look back at them and say, oh, I wish I had done this differently or decided this case differently.
I'm afraid it doesn't look modest if I say, no, I don't think so.
Okay.
I had a lot of efforts, not decision came immediately, a lot of work, this was the best of my judgment. I don't know. This is how I thought. Of course, you can always do better. And I hope the next generation is doing better. But this is a uphill fight, not an easy one. Maybe there are things that, you know, now when after we have legislation as to human rights, after we have all the judgments, things could be, you look differently on things, but not basically. I mean, of course, views are not the same. We are going with, from year to year, we change many views. We think maybe things would be better if, but not the things that we did, the battles that we had, and I had enough. I don't regret.
That's wonderful. You left the court in 2012. Tell us a little bit about what you've done and are doing now. Your activities since leaving the bench.
Yes. If I compare to the work I had, it's not, I was teaching. I taught I had seminars in university in Tel Aviv, in Jerusalem, at NYU, 5 years at NYU, a semester. And of course, the main thing that I did was security and law. This was the main topic there, how to strike the balance. We found many problems similar. Of course, every administration, the solutions are different, but the problems are similar, basically, comparative with the United States, this also. I'm the Chancellor of the Open University. And the most important thing is, in my view, education for the younger generation. Wherever I can, I speak, I lecture, because I really think that I think that without having a written constitution, although I'm not sure that this is such a guarantee after the experience we had in the United States, but without a written constitution and with the political interest to have more power as we feel now and to take power from the court, because this is one of the issues now that they discuss here. I believe that only education, democratic values, and to understand what it means. They always say, we have the power because we are elected. I think the court has the power because it's not elected body. It's not an elected entity, not afraid of to be popular and being independent and keeping the values of democracy. And I keep saying it everywhere. This is what I'm doing in many occasions. And of course, I said the Open University is something very special to us. It's the largest university in Israel. As a chancellor, I'm not doing the work of the university, but I'm involved. That's what I can tell you about my...
Could you talk a little bit about the Open University and describe what it is?
The Open University is a very special model where students are admitted with no preconditions. Everyone can come to the university. The level of teaching is high, but the idea is that we have to bring all sorts of societies and groups and give them the opportunity. So we have people sometimes even from schools, but later, of course, while they're serving in the military, Arabs and people who are that didn't have the opportunity to get the education. This is the high level of education given to people that can, if they cannot afford it, we are supporting. This is the largest. We have more than, for Israel, 45,000 students. It's also studying from distance. Not everything is face-to-face in a class, but this year it showed how important is the distance learning. We started it here, now it's very much needed, as you know, because of the pandemic. And I think we have very good research achievements, teaching achievements. It's in my view, this is also a mission to bring more education and culture to more layers of society. And this is what we are doing.
I can't resist one more question. You have taught at NYU for 5 years. You taught in Israel for many years. Do you see a difference between the American law students and the Israeli law students overall?
Well, you have many Israelis coming to Berkeley, and if you ask
Yes.
them, they will all tell you. I have to be very careful about it. But the American students that I met were very serious, were prepared in their classes. Here, most of the students, it's seminars here and there, so it's different. They all did their work very nice, curious, those and those. And I loved it, I must say, because of the dialogue and the opportunity to meet young students who are so much interested and curious in learning law and the issues of law.
That's my transition to allowing two of our students to speak with you. I'm going to introduce them, and I think for about 10 minutes, they're going to talk with you. Then I'm going to come back, and we've got many questions from the audience that I'll pass on to you. But I think right now we have Rebecca Steinberg and Hannah Wenger, who are going to come and speak with you. And
Welcome.
thank you, Justice Beinisch. This has been such a treat for me to have the chance to have this conversation with you. But I will be back with more questions, and I'll turn it over to Rebecca.
Thank you, Chemerinsky. Thank you so much.
Good morning, Justice Beinisch. Can you hear me all right?
Yes, please, go ahead.
I'm so honored to have you with us today. My name is Rebecca Steinberg. I'm a junior studying English and human rights, and I am an undergraduate fellow at the Institute. Now, earlier you touched on the impact of the pandemic on Israeli education. My question is a little broader. What has Israel's management of the pandemic and the vaccine rollout revealed about the differences in Israeli and US legal systems, whether that be their mechanisms in healthcare, contact tracing, vaccine green cards, and the like?
I don't know. I can't tell you exactly because you need to know about what's happening everywhere. And the feeling that I have is the surprise of the pandemic. No state that I know was prepared enough, not even such a great state like the United States with all the possibilities, and not us. I think here what was important and influential in this pandemic, I mean, the damage was a lot of damage if we're talking about students and pupils, and the year almost wasn't, they didn't learn in many of the cases or from distance. But we had the vaccine, we had our medical system is organized, and the medical assistance to everyone is obligatory. Everyone has it and has access to get the treatment and the vaccine. The problem everywhere, I think, in different levels, was the governments were not always prepared, the schools were not prepared, and they had to change the decisions from day to day and to separate between political considerations and practical medical considerations. And I think this was not a success in most of the countries, and I'm not sure. In a way, we did better. It took time. It took time. And I hope we are over, but we don't know yet. I hope so. So I don't know if there is anything special you want to know about it, then ask me.
Hi, Justice Beinisch. Thank you so much for being here today. My name is Hannah. I am a junior studying political science, and I'm also an undergraduate fellow at the Institute. So I wanted to ask, what has been the most difficult decision you've had to make on the court, and why?
Well, this is a difficult question. Many cases that come to the court are difficult. First of all, there are different things that make it so difficult. If it's the fate of a family, if it's a private thing, if it's an issue of children, and some have a political influence, a social influence. Every case is serious. I don't think that there are most of them demand, I can say what was the most difficult case. When you have to decide about adoption of children, it's difficult. When you have to decide about protecting life in certain settlements, it's difficult. When you have to decide things that are against the decision of the government, I can tell you that a case that was very famous and problematic was if we have to protect schools in an area more than the government decided, where they had missiles day and night, and the children weren't safe at school. And the government said, we gave enough protection, we have shelters, we have no money for more than that. And then you say, no, it's not enough because you endanger the children. Those are all very serious issues that you have to decide. And this is what's so interesting and important in this work. This is what, there is no one case, many cases are difficult. But to solve a problem, a private problem, an individual issue, and a public problem, all of them are really important and difficult. That's what I can tell you in a nutshell. Yes. Who else?
Hannah, Rebecca, do you have other questions? Well, let me go ahead. We have many questions from the audience, hard questions from the audience, but let me start asking them. First question, I'm reading this. It's about the connection of politics, government, and the court. Has the inability of the Israeli political system to form a stable government impacted the work and ability of the Israeli Supreme Court and subsidiary courts?
Well, this is really a difficult question. I mean, what is so important that the court will adhere to its principles, to its norms? A situation is complicated, and then when it comes to the court, it becomes a complicated question for the court. If it has a political effect, ramifications, the court has to be very careful to give the right constitutional decision and not to play a role in politics. The important thing is many decisions have influenced politics, of course, but the point of view is not a political one. It's a constitutional one, it's a legal one. Politicians sometimes think that they can't understand that judges, they cannot accept the judges are doing it not because of their political view, but because of their professional view. And there is everywhere there is a collision. It's not only an Israeli problem, but as you said, the unstable situation here and the fact that the Israeli court, we don't have an argument of non-justiciability, which means it's justiciable, but we are dealing only with the legal aspects of the problem. Yet it's a very delicate border. And this is how the court has to function.
There's a question that's come about a role of a case that your role in a case that when you were state attorney. I'll read you the question. You had a large role in prosecuting the Shin Bet officers involved in the Bus 300 affair in 1984. Talk a bit about what it was like to work on that case.
Well, this is such a story that in an evening, in a morning for you, evening for me, celebrating this institute, I cannot elaborate on this case. This was a very, very difficult, it wasn't a court case. This is part of the job of Attorney General or State Attorney. When they find, we were talking about corruption, when they find that you have to investigate what happened in a security service. The service is strong, they don't like you to do that. The Prime Minister gives the backing to the security service, and then you have to try and convince them that you have to investigate what happened when something very, very bad happened. So this was a fight of a year, And next, if we have an opportunity to celebrate the next anniversary of the Institute, I'll tell you about it because this is a long story. It was very hard. All the politicians, all the government members, and the Prime Minister were against the Attorney General, the State Attorney. A lot of problems until those people had to resign, they were pardoned. It was very complicated. One of the very, very hard cases to fight. But this is when I said that sometimes we have to be independent and not to go in a line where it's easy and comfortable for Prime Minister or for the ministers or a security service. This is a very good example.
And I think I can speak on behalf of the Chancellor, Ken, and Ron. We would love to have you come back for our next birthday celebration and do another conversations like this. Let me read you some of the other questions. What is your opinion of the role of international law? How did international law impact your work on the Supreme Court?
Yes, I think it's a good question because we do refer to international law. But this is part of our very special situation. Again, keeping the territories that Israel keeps, they are under the rules of international law. I mean, it's the law of occupation, although it's many years and it's not just a short transition time. And we applied international, it's not exactly, or in the fight against terror. Nothing in the conventions, international conventions are exactly adopted to the special situation that we have to tackle. But we did take the norms of international law. I mean, also in internal problems where we are parties of conventions, of international conventions. But the main thing that we use a lot of international law is when it has to do with the territories, with norms on people that are in the territories who are protected persons under the international law. And every move or the means used by military are also overlooked by the court, also in accordance to norms of international law, for Geneva Convention, the humanitarian part of the Geneva Convention, with an interpretation of Israeli court because of the special situation. But we do use a lot. We used to. Yes.
A question about a different area of law. It's about environmental law. And what's the state of environmental law in Israel?
In my view, not enough developed. I mean, we have legislation, we have, of course, special ministry for environmental, but I don't problems, but the changes now and the need to protect the environment, and there's a lot to do. We tried, we had cases like that, and there are, of course, as I said, laws of many that are have to protect the environment, but I think it's not enough in what we have here and what we do about it. When it comes to the court, of course, applies the legislation and the law as to environment. But there is more to do.
A question that I'm particularly interested in, ideology matters a great deal in how the American Supreme Court decides cases. Is that true in Israel at all? Also, has the Israeli Supreme Court experienced a similar rightward shift as in the United States Supreme Court?
Very delicate, important question. When I served in the court and for years, I always believed, and I still believe, that the court, of course, every judge, every justice of the Supreme Court has his views, but we made, I mean, the best. We tried to be really not political. It's not a political court. The system is not political like the American system, or it's part of it, having the Senate approve the judges, having the president appointing the judges, it's political and declared political. So sometimes you see how in your court, it depends who appointed. No, they don't always succeed, but in history, they didn't always succeed. But this is part of the ideological. I always believed, and all of us, the judges, think it's not the way to appoint judges, and it shouldn't be political. But this is part of the issues now discussed here, because politicians believe that, of course, if you render a decision, it's for political motives. This is how they understand, because they think differently, how they understand the decisions. So if you limit things that, or you give decisions that are not popular, immediately they will say it's a leftist court or a right court. I still believe it's not like that, but this is part of the wish to influence the court politically by those who appoint the judges, and we didn't have the time, or we didn't discuss how they are appointed in Israel. But there is now a strong tendency to imitate the American idea of political nominations.
Many of the questions that have come in concern the basic law and trying to understand how the basic law is similar to or different from a constitution. So one of the questions came, has the basic law evolved and can it be compared to US constitutional amendments?
The basic laws are, it depends. We have few kinds of basic laws. As I said, we have, this is also an issue discussed now all the time. We have the structural basic laws, which are, I mentioned before, they make it simple. I mean, simple and not simple, because there are no limitations of amendments. And this is one of the problems now. A basic law should be like a constitution, not changed by every government and every elections to change the basic law. They are not immune. They are not, you can change some of the basic laws, you can change in every majority of the legislature, which actually what we really need is a basic law of legislation, where we will know exactly how to amend a basic law, how to change a basic law, and how to immune certain paragraphs that should be eternal or strong, and not to amend them by every political wind blowing. This is not enough. What we have is not enough. The court tries, but if you have no constitutional limitation, to amend the American Constitution is very difficult. To amend the basic law is very easy. And this is sometimes used not as it should be. And this is one of the very important constitutional issues that we have now.
I'll read you another question. It's about individual rights and freedom. How are individual rights freedom different in Israel and in the United States? Does that impact the ability to impose compulsory vaccinations, security protocols, and the like? It's obviously a very broad question, but it basically gets to what we were talking about earlier in terms of how do you balance freedom and security?
It is difficult to give a short question. In different fields, it's different. It came up now this year, and one, I think it was Hannah, or that asked about it, vaccinations. There is no force for that. And the question and the problems came to the Supreme Court. Can we follow people who didn't, or ban them from going to their work or to be teachers? Or how do we, a lot of problems that this pandemic put. How do you act when you have to protect the people on the one hand, and on the other to protect the people from infringement of their rights? This was always with us as to security. And this was the first year when we had similar problems. Could the security service follow and trying to find out how this person got the virus? whom did he meet? Very serious problems. And the court decided that it should be by legislation of the Knesset and to put limits on it. And this was one, maybe this was the first question that I was asked. This is an issue that was talked about and dealt about a lot in our court. There is no one good answer to that, but this is the main role. We have to do that.
The next question came in terms of, is there sufficient independence of the Israeli Supreme Court from the government, or are they perceived as representing the politics and policies of the state?
No, first of all, it's an independent court and the government cannot interfere with the work of the court. Although we don't have a separate authority for the budgets. From this point of view, you can say this is not a complete independence, but professionally it's independent. The court is very, I think so, and I wish it will never change. Again, things that politicians do not like so much, but you can't protect democracy if you don't have an independent court. Those are, of course, basic norms. A court should be independent. One of the ways to interfere with it is the system of appointing judges politically, or things that this endangers, in my view, the independence, and we are not there. I hope it will stay like that.
Thank you. There was a question about a specific case that you had talked about earlier, and that's the case that outlawed corporal punishment. And the question was, what was the legal basis for the court to conclude that corporal punishment was impermissible?
Well, I would ask, what is the legal basis to allow corporal punishments? That was my idea. Why? Because it's a parent. He should educate his child, bring him up. Very good. But why? Because he's weak, because he's little, because he has no power. We may use force against him. This, it comes from a very, very old Jewish norm from the Bible. Spare thy rod, spoil thy child. This is also cited by Canadian courts, American courts, and British courts. The same. This is where they like the Bible. But I think it's the basis is that you cannot inflict corporal punishment or power. This is not that you have to indict every parent for taking strong the hand of a child that runs to the road or to electricity, and it remains always the discretion. Not everything is criminal, but we never knew before, I must say, how there is abuse of children. We found out during the years it's not an Israeli phenomenon, it's a serious phenomenon of abuse of children, using corporal punishment against them and other abuses. And it shouldn't be allowed, and it is not. You cannot use force against any person and not against a child, unless we are talking about necessity to save him. This is something different. So there are, of course, defenses. No rule is absolute. There are defenses, but it is not the permission to use power or force against children. So
one of the questions goes to, Israel is a vastly smaller country than the United States. How do you think that changes the role of the state attorney or of the Israeli Supreme Court?
Because Israel is a smaller country.
Much smaller geographically.
It's so different. I mean, I always think that the United States has so many problems of the federal system and the state system. And I just followed now your case, the American case of, in the case of, well, this week, the jury's decision about Florida.
Derek Chauvin.
Yes, Chauvin. I followed it. I watched television all the time, your television. And I thought, we are so different. You have a complete federal system, a state system. We are one, as you said, we are small, one system. We have no jury system in Israel. The courts are professional. It is one establishment of courts in the country. The administration is much easier. The access to the court is easier. We didn't go into it. We cannot go in a short conversation. It's very different. Yet we share many norms together of a democratic liberal state. So sometimes you see that the same issues come to a court. One of my decisions was unequal payment to women who do the same work as a man in the same place. Very similar, almost similar to the late better case that you had in the United States. Problems of same-sex marriage, problems of new families, all those problems we share all common problems, and we learn from each other. We use a lot of comparative law. We try to know how did other courts in other countries, in other systems, solve a problem which is very similar to our problem. With this, and courts have a lot in common, and we have very good relations with many courts in the world, our court. Sometimes it's easier to discuss issues with other courts than with our people in the political field, which we cannot discuss. So it's very different, yet in a certain way it's similar. That's what I can say.
I think that's a wonderful place for us to end our conversation. I can't thank you enough for taking the time for this. I learned, and I know everyone who listened learned so much from you. And I only wish, having listened to you and having read your opinions, that you had been our Attorney General and that you'd been on the United States Supreme Court. We really needed you.
No, I think you succeeded very much now after an experience that you had.
We would agree on that.
Looks better.
I think with that, I will turn this back to my wonderful colleague, Ken Bamberger. But from the bottom of my heart, I thank you so much, Justice Beinisch, for this terrific conversation and honoring us with your presence today. I know if we were together, you would get a standing ovation at this moment.
Thank you, Dean. Thank you very much. It is so interesting and good, and I'm happy I could talk to you. And I want to thank you all for having me and listening with patience. So thank you so much. And I'll thank, of course, Ken Bamberger for this. Here is Ken. Hi.
Thank you so much, President Beinisch, Dean Chemerinsky. What a lovely conversation to get to listen in on. Thank you so much, Chancellor Christ, for being here today, celebrating with us, to our fantastic students, to all of you for coming and joining us. And we invite you back in 1 week for our last program of the semester, The Art of Leaving, a conversation with Israeli author Ayelet Savari, who is going to be talking about her memoir, The Art of Leaving, and its themes of longing and belonging, growing up Mizrahi in Israel, and reclaiming her Yemenite identity. Thanks for being here. Please join us soon.
Good luck and success to the Institute.
Thank you so much, Justice.